Welcome to another episode of Living Justice, Living Leadership. I'm your host, Lee Fisher, Dean of Cleveland Marshall College of Law at Cleveland State University. You know, I've had the great privilege to live my life at the intersection of the public, private, nonprofit, and academic worlds. As a lawyer, CEO of 2 nonprofit organizations, and as a state legislator, attorney general, and lieutenant governor. And the lessons I've learned come down to just 2 words: justice and leadership. That's why every week we'll talk to people who are walking the walk. Some are lawyers and some are not, but all of them have something in common. They are change makers. They are guardians of justice. They are living justice, and they are living leadership. Welcome. This is part 2 of my interview with Ohio Supreme Court Justice Michael Donnelly. You're not going to want to miss this, so stay tuned. Are there any cases that stand out in your mind during the 14 years you were on the Court of Common Pleas that you sort of would be in your memoirs if you ever write them?
Oh, there's so many. We'd have to extend this podcast by another hour. I was fortunate to try virtually every type of case that a common pleas judge sees, and being a common pleas trial court judge is tough. You see a lot of misery and bad things that happen to people in their lives, and I am sure there were murder trials that involve sexual assault that I suffered from some level of post-traumatic stress. People in other professions aren't there, but it's important that we're there and to be cognizant of that fact. I think that in addition to the trials, the observance of the plea bargaining prospect from this new perspective had an even greater impact than most of the trials had on me, on thinking about the system and how it could be improved. And what I always tell people, and I've written about this in a number of articles since I joined the Supreme Court, I never questioned as a prosecutor the practice that is still employed in Cuyahoga County and throughout Ohio. When prosecutors and defense lawyers negotiate a tentative plea agreement, the next step in the process is to go see the judge to see if he or she would accept the agreement that the 2 adversaries have reached. And usually the defense lawyer is looking at that same meeting as an opportunity to explore what the consequences that are going to occur if they enter that plea bargain. And when I started as a judge, I engaged with the adversaries the same way I learned as a practicing attorney. I would invite them back into chambers. There was no court reporter there. The parties weren't there. And they'd tell me about the case. And we discuss what the potential consequences would be. And I would make representations to them back there. And gradually, in my first or second year, I started to question why we do this in our system. Why do we have these off the record discussions in the back room? And I eventually came to the conclusion that I describe as the greatest epiphany in my legal career was this notion that no one should ever say anything in that back room, including the judge, that they wouldn't repeat verbatim out in open court and on the record. So one day I said to my bailiff, John Thomas, I had a great bailiff all for 14 years. I said, John, let's do things a little differently from now on. Tell the attorneys we'll still have the same discussions that we've been having back here, but from now on, we're just going to do it in open court where the court reporter is going to take everything we say down And I went out, and that morning started doing it. At first, it caused quite a bit of stir in the courthouse because the attorneys had the impression that I wouldn't talk to them anymore, that at all. And we had to clarify that. And we just said, no, we're going to have the same discussions, but we're going to have them all out on the record. Because when you're on the record, it tends to make everybody focus on the merit or the lack of merit in what is being litigated in the case. And if you have discussions about what the consequences are going to be, you can make those representations, and then I'm held accountable. I don't get to change my mind 30 days down at the sentence. And that's just not the case uniformly throughout the state of Ohio. And I truly believe we need some reform, not only in the plea bargaining process, but in our sentencing laws as they exist right now. And I probably wouldn't have been able to gain these perspectives if I was not fortunate to be elected to the trial bench and see the system from that different perspective as a neutral in the process.
You've achieved a national reputation on this issue, so let's spend a little bit more time on it. What can be done to change the system?
Well, I think the bottom line is transparency. The transparency is the ability for the public who we serve to feel confident that the system is running as designed. Yet you have a prosecutor seeking truth and justice, and discovery is being exchanged, and defense lawyers who are equally, just as prosecutors, equally essential to the process of as to why aren't other judges doing this? What's the counter argument of doing everything on the record? What is the proper role of the judge in the plea bargaining process? Why do certain judges accept agreed sentences from the parties and some don't? Why do certain judges sentence more severely than even the prosecutor is seeking in a particular resolution? What guides them to do that? That's something that I've questioned, that I've had questions over the years. But since joining the Supreme Court, the number one key that I have come to believe is the most important reform that we could advance, that underlies all the flaws in our criminal justice system that could be addressed, is the collection of relevant data in our system that does not exist. Every action taken should be, in this day of technology, recorded and stored in a database that is accessible to all the stakeholders in the system, including judges, prosecutors, defense lawyers, and most importantly, policymakers who make the laws. You know, the sentencing laws that we operate under right now in the state of Ohio are antiquated. They were implemented way back in 1996, and they provided wide ranges for certain crimes that were not based on anything other than the collective gut of the legislature at the time. And they weren't based on what works, what's appropriate, what's proportional. They just picked ranges, and they gave the power to the judges, and they didn't give the judges any guidelines to promote consistency from courtroom to courtroom. They gave them presumptions in favor of incarceration. They gave them presumptions in favor of probation, what we call community control, but every individual trial court judge that's elected in the state is free at their own discretion to ignore those presumptions or follow those presumptions. And we have a system that really doesn't have the guardrails that a system should in order to prevent disparate treatment of individuals from courtroom to courtroom, excessive sentences that are not proportional to the crime involved. And there's no, unfortunately, because of a few decisions that have come out of my court, the Supreme Court of Ohio, decisions which I dissented vehemently on, we pretty much decimated this concept of meaningful review of sentences, where our appellate courts feel that their hands are tied behind their back if they're reviewing a sentence that they believe is unjust, that isn't supported by the record. As long as it's within these statutory ranges, they feel they're powerless to change it. So I can't stress enough how quickly we need to move in this direction to collect important, relevant data so that policymakers can provide those guardrails in the system and make laws that protect the community, but that also that are also proportional and deal with the process of implicit bias. And when I bring up implicit bias, there's a big misunderstanding of what that concept is. Some people believe it's the equivalent of racism, and it's not. Biases are something that every human being, every decision maker on that bench possesses, conscious or unconscious of, and it can affect their decision making. And when you're making important decisions about how many years to sentence someone to prison, there has to be tools and information available to you to keep those biases in check and keep your sentences consistent. And that's what I'm most passionate about as something that we cannot drop the ball on. This is something that has been called for since 2002. Then Chief Justice Thomas Moyer formed a racial justice and fairness task force. And this is one of the number one things, even way back then. That's before I became a trial court judge, asking for the judiciary to start collecting this data. And we cannot drop the ball at this moment in time when people are demanding change. That's been, the silver lining in the tragedy of what occurred in Minneapolis with George Floyd has sparked a moment of change that I haven't seen in my career, a call for change to deal with the problems that not only exist between encounters between the citizens and police, but permeate the entire system, from the charging process, through the plea bargaining process, through the sentencing process, and then through the post-conviction process. There's so many opportunities to improve the system and make it better for the Cleveland Marshall students who will soon be taking over the roles of looking for even better ways to improve our system.
Will this comprehensive data collection require state legislation?
I believe it will. Right now, we're trying to convince judges in the 88 counties, and we made huge steps. Judge Jean Zamuda from the 6th District Court of Appeals, Judge Bergeron from the 1st, and Sarah Andrews from the Sentencing Commission, they've come up with this uniform sentencing entry that would be the mechanism in which to collect the important data points that we would need to be able to compare apples to apples once we have this database in place. And right now, we're just trying to build consensus among the judges in those 88 counties to start using this. We call it the use uniform sentence entry. But there's nothing that requires the judges to do this. And the only body branch of government that has the power to tell judges what to do is the legislature, and
Right.
I think that's going to be ultimately the step. But you know, what's encouraging is once new judges and judges who were perhaps reluctant to embrace this idea at first, once they start learning of the power of data to make better, more informed, more fair decisions, they're all on board. And one by one, we're gaining new supporters on the bench every single day for this effort.
How has your life changed, both personally and professionally, since you've started to serve as the 160th Justice of the House Supreme Court? And how has it changed, if any, your view of the law and justice?
Well, it's funny. I loved being a trial court judge. I never, ever in a million years thought I thought I would retire a trial court judge, because I loved being part of that process of bringing resolution to conflict in people's lives, whether it was a criminal case or a civil case. You know, you're dealing with people whose lives are in crisis because of the dispute that is in front of you. And I loved watching lawyers do what lawyers do and advocate for truth and justice for their clients. And I realized just what an important role lawyers play in our democracy. So I never thought I wanted to leave there. It was high pressure. I would equate the pressure a trial court judge experiences to that of a emergency room doctor. And then when I won the seat in 2018 and packed up all my books and belongings and moved out of the Justice Center, and I didn't have to be down in Columbus until the second week for my first round of arguments. So I woke up, grabbed a cup of coffee, and stared at my two dogs, and looked at the pile of briefs that I had to start reading. And I said, what have I done? You know, at first I had this feeling like, did I make the wrong decision? And but fortunately, now with nearly 3 years into it, it's just I relish the position because the cases are fascinating. I love working with my 6 other colleagues on the court. Even if we vehemently disagree about our positions, we still, pre-COVID, we'd go out Tuesday night, all the 7 of us, and have dinner somewhere in Columbus. And what I relish the most is the time to think about my decisions that you don't have at the trial court. Trial court judges make 100 decisions a day and a mile a minute. They don't have time that I have now to contemplate and change my position if I'm persuaded that my initial inclination is incorrect. I think that's one of the most important qualities a judge can possess, is the ability to keep an open mind and be persuaded that you may be wrong in the position you initially take. So I find the process fascinating, and it's given me opportunity to write about ideas about reform, observations I made while on the trial court, and I've enjoyed that aspect as well. It's tremendously intellectually satisfying.
It seems to me that there couldn't be anything much more fulfilling in a legal career to be able to have practiced criminal law, civil law, be a judge on the trial court level, and then a judge on the House Supreme Court. You're seeing it from all different perspectives, all different angles, all different sectors. And it seems to me if more judges had the kind of varied experience that you have, we'd have a better judicial system and more justice meted out.
It's been very helpful to me, especially in cases that we're deciding that are going to have huge impacts on the trial courts. I'm able to articulate that in conference and I do think it's important to have those perspectives on the appellate court and the Supreme Court, so that those views can be properly expressed when necessary. But also fulfilling is, now that I'm in this position and I have time, I am able to do what I campaigned on, and that is work on initiatives with all the stakeholders in the system, where we can sit down and we take off our hats, our respective hats, and we say, what's happening in the system? Are we satisfied with it? And can it be improved? When I first was elected in 2018, I went to the Chief Justice and I said, Chief, I really want to work on a task force that works on the post-conviction process for people who claim that they are innocent, because the stars really have to align for these people to have a second look taken at their case. A lot of times they request hearings. Those hearings are denied. Sometimes motions languish on dockets for years. Sometimes you have to have a combination of the press or a celebrity backing you in order to get that case looked at. And it shouldn't be that way. We should have an efficient system on the back end so that these cases can be remedied. And to the Chief Justice O'Connor's credit, she said, absolutely, I agree with you. She was in the midst of a bail reform effort at that time. She said, come to me in the fall and we'll do it. And I called her in the fall, and she appointed me a liaison. She appointed Judge Jean Zamuda as the chair. And we've been working all through COVID on some new rule changes and some new legislation that I think, if it's implemented, and I'm dedicated to see the implementation carried out, it's going to advance the post-conviction system light years from where it is now, and hopefully, provide a pathway, a much more efficient, transparent pathway, so that wrongful convictions can be remedied ASAP in our system, and ways to prevent them from happening in the first place on the front end.
I'm glad to hear that, because one of the great indictments on our American justice system is that still to this day, too many innocent people are being convicted, and too many of them are being put to death. And
Absolutely.
Only later do we find out that they were innocent to begin with.
Absolutely.
I want to go back to something that a lot of our listeners don't know, and that is that you're somewhat of a movie buff, and you particularly mentioned one movie in particular, A Few Good Men. And Professor Pam Diker-Middow at our law school teaches a course on film and law, and every year you come in and give a guest lecture on Few Good Men. So let's pretend you're in class right now. What are some of the lessons of that great movie?
Oh, there's so many lessons, and I'm so grateful to Professor Diker-Middow to invite me back every year. I love interacting with the students after we watch that movie together. So each time I watch it, I've probably seen the movie probably 200 times now, and I can recite every line, but I'm able to provide them with a few points to keep a lookout that they may overlook in the film. Different themes about fair play and honesty. I love the character of the prosecutor, of Kevin Bacon, because he's so forthright and honest in his interaction, and it proves that in our system you can still be friends and civil with your adversary. You can interact and still provide just as much zealous advocacy on behalf of your client. There's a great scene at the beginning of the movie when Tom Cruise is playing softball, and he missed an appointment with a prosecutor, and they go through the essence of a plea negotiation, where the prosecutor starts out asking for a more severe sentence recommendation for a marijuana charge or something like that, but which was really oregano. And you see the back and forth of the resistance that the defense lawyer provides, and you see a really a microcosm of how plea agreements are negotiated and come to a just resolution. And I tell them to watch that. And I tell them about the importance that often gets overshadowed in our adversarial system, that our main job is to, when we're resolving disputes, should always be what is the truth, and never letting truth overshadow anything for the sake of resolution. And that's really the theme of the movie when Tom Cruise presents to his clients a deal that he's negotiated that even an innocent person would be probably foolish not to take. His clients refuse to take it because they feel that they would be admitting to something that was not true. And that is when Tom Cruise reaches his the point where he says, I have to go in to trial and overcome his fear of going into trial. I think that's an important movie for young lawyers, because if everyone was honest, when you go into the system, I don't think there's anyone that doesn't have that initial nervousness about being an advocate, standing up, making arguments, and very few people don't have that. And that's another theme in the movie about overcoming your fears and preparation, the importance of preparation. There's so many great lessons, and I hope the professor keeps inviting me back, because anytime she does, I will be there.
She will. And I close out each of these podcasts, Justice Donnelly, with asking you some leadership lessons you've learned throughout your career, because one of the things we do at our law schools, we don't just teach law, we teach leadership. So I'm putting you on the spot, but if you had to say, what are the 2 or 3 most important leadership lessons you've learned in your personal and or professional life, what would those be?
Leadership, I believe, first starts with listening and understanding. And leaders exercise power. And power is, as I define it, simply getting the people that you are addressing to do what you want to do. So if you want to be a leader in a reform, you build consensus, and you empower other individuals to also be leaders as part of your effort. And that's what I've always tried to do. You cannot get anything done by yourself. You have to empower people to use their own talents and buy into the idea, and then let them be a part of the process. Let them never be someone that the worst leaders are, in my view, unable to share credit with the effort. You can't get anything done without working together. So when credit is needed to be expressed, you have to express it to the people that help you get where you want to get. That's how I view a good leader: someone that listens to someone who is willing to change their position if convinced that it's wrong, and who empowers other people to help you get where you want to go.
We've been listening today to Justice Michael P. Donnelly, the 160th Justice of the Ohio Supreme Court. Like many of our podcasts, we could go on for another hour, but we covered a lot. And I'd like to say, Justice Donnelly, when they write a book about the history of the Ohio Supreme Court, the title might be A Few Good Justices, and there'll be a chapter on you.
I appreciate that. Thank you.
Thanks for taking the time today and joining us. And thank you for listeners for tuning in to another podcast of Living Justice and Living Leadership. Thanks again.
Thank you, Dean.